Since the Supreme Court decided that gay couples can get married, those marriages have been legal in all 50 states of this country, including Georgia. What that has resulted in is a whole new aspect to the concept in the law in regard to divorce. Same-sex marriages, a divorce follows the same rules as different sex marriages, unless there are children involved. If there are children involved, it becomes a lot more complicated. There's not a lot of law in regard to this, and judges are kind of shooting from the hip trying to figure out what to do with it. And so it's kind of a whole new area of the law that no one is certain how it's going to involve. But what we have found through representing parties in these type cases is that if a child is conceived during the marriage, quite often through artificial insemination, it is the child of both parents, both parties in the marriage. And when a divorce takes place, the court recognizes the rights of both parties as if they conceived that child. If an adoption has taken place, generally both parties have adopted the child. If an adoption had taken place and only one of the parties adopted the child, that puts a whole different outlook to it. The party that did not adopt the child may not have rights. You have to look in the facts and circumstances of the case. There's a little-known law called virtual adoption. Very few people understand this or even know it exists. But a virtual adoption is where a person who is not the biological parent of a child and has not adopted the child acts and participates in the child's life as if they were a parent. And the court can, based on case law, determine that there has been a virtual adoption of that child and establish parental rights. These are very rare circumstances. We have dealt with them. There are cases where a child may be conceived during a marriage between two same-sex people, but there's a third-party father, usually, that's not a party to the marriage, making claims in regard to that child. The courts have to look at what's in the child's best interest in determining those claims. It gets very complicated, and every case has to be weighed upon all the facts and circumstances of that case. The court's going to look at what's in the child's best interest. They're going to try to apply the parental rights doctrine. Some judges are going to apply those doctrines one way and some another. There is just not a lot of case law out there in regard to this subject. So it's important you have an attorney that understands the subject matter, that can develop the facts, all the circumstances, and present them to the court in the light that best supports your position in the case. If you're a same-sex couple going through a divorce and you have a child, you're probably wondering, what does the best interest of the child mean in your circumstances? It really means the same thing that it means in a heterosexual relationship. The court is not going to take the fact that you are a same-sex couple into consideration in trying to determine custody. They're not going to use that against you as they would have in the past before Georgia recognized same-sex marriage. It's basically who's been involved in the child's life, who takes care of the child, what's the child's life going to be like with one parent versus the other parent. Who is the person that bathes the child, feeds the child, takes the child to the doctor, takes the child to school, participate in all the things that a child needs a parent to participate. Same-sex couples are parents. Best interest of the child looks at parents' participation in the child's life and what they can provide for the child after the divorce. Not necessarily financial, because financial issues can be divided and shifted to allow a particular parent that has been actively involved in a child's life to have the financial means to meet the child's needs. So I'm not talking about money here. I'm talking about participation in the child's life. Who is the best parent? Who's going to take care of that child properly in the way that the court sees is in the child's best interest? Since same-sex marriage has been recognized in Georgia, it's been my experience as judges bend over backwards to avoid any appearance of bias against same-sex couples in regard to children, in regard to division of assets, alimony, or any of the other issues involved in a divorce. They simply don't want the finger pointed at them by society as saying you are biased against gay people. I have not seen that as a issue in divorces when Daniels and Taylor has been representing same-sex couples. I'm not saying it doesn't exist, but we've not seen it in Gwinnett County. Same-sex couples can expect the same custody and parenting arrangements that heterosexual couples can expect. I don't think the courts are going to treat them any differently in regard to custody and visitation with their child. The most common custody arrangements are one parent having physical custody, the other parent having visitation rights, or joint physical custody where the child rotates back and forth between the parents pretty much on an equal basis. Visitation rights most commonly are every other weekend, a midweek visit, alternating holidays, and some time in the summer. Custody in a divorce for same-sex couples is pretty much identical to heterosexual couples. The court uses the same standard, the best interest of the child, in deciding the issues before it. They want to make sure that child's needs are best met in whatever way possible.